first panelist is law professor Robert Vischer. Professor Vischer serves as the Associate Dean for Academic Affairs at the University of St. Thomas. His scholarship explores the intersection of law, religion, and public policy, with a particular focus on the religious and moral dimensions of professional identity. Professor Vischer has published books and writings on law and Christianity, and was previously an assistant professor of law and a fellow of the Vincentian Center for Church and Society. And just as a brief note, each panelist will speak for 15 minutes, and then there will be a Q&A afterwards. And if everyone can please turn off your cell phones now. With that, Professor Robert.
Thank you. I appreciate this opportunity. I'm going to address this bill as a law professor and as a Catholic. And I'm going to take a few minutes to try to put the current anti-Sharia law initiatives into a broader context and explore whether the introduction of Sharia law in American courts is really a departure from our legal tradition. I think the best way to come at this is to ask, how does American law already create space for the introduction of distinctively Christian beliefs and commitments? In other words, do bills like the one proposed here defend the rule of law, or are they themselves in tension with our society's long-standing commitment to religious liberty? At the outset, I think it's important to recognize what Sharia proponents are not trying to do. They are not seeking to have American law adopt Islamic rules of conduct. If they did, I would be first in line to object. The Establishment Clause is a key bulwark against harnessing state power to impose the tenets of any particular religious tradition on citizens. The more pressing issue for religious believers is whether they will have the liberty to live out their faith commitments in the world. In other words, Muslims and other religious believers who are troubled by anti-Sharia proposals tend not to be focused on conforming American law to their faith tradition, but rather on maintaining space in which they can live out their faith tradition without interference from the state. In particular, the introduction of Sharia law in court is not generally aimed at establishing a freestanding source of law binding on the litigants, but rather at recognizing the norms to which the litigants have already agreed to. American courts do this every day. It's called contract law. I'm not an expert on Islam in any sense, but I do know that marriage contracts are very important in this tradition. Indeed, in Islam, my understanding is that marriage is a contract. There is no priestly ritual that constitutes the act of marriage. There is no marriage absent the contract. I also understand that the marriage contract usually provides for some immediate gift to the wife and a gift that is owed upon divorce or upon the husband's death. If courts are prohibited from enforcing contracts that shape the terms of the marriage, the loss to a Muslim's religious liberty is even greater than the corresponding loss to a Christian's religious liberty. The freedom to order one's life in keeping with one's religious commitments is arguably even more central to Islam than it is to Christianity. This is in keeping with the broader distinction between Christianity, which is based primarily on faith, and Islam, which is based primarily on right conduct. I'm speaking very broadly as a non-expert on this. And yet, we are seeing a greater willingness to encroach on Muslims' freedom to order their lives in keeping with their religious commitments than we have seen with regard to Christianity. For example, it is routine for a court to look to the rules of a religious entity in order to resolve a conflict within that entity. If a Baptist church creates a constitution that says a pastor can only be removed by a vote of the entire membership, a court will uphold a challenge to a church committee's effort to dismiss a pastor absent a full membership vote. The fact that the church's rule flows from a Baptist commitment to the priesthood of all believers, in other words, the rule is a religious rule, does not preclude a court from enforcing it. To hold otherwise would put the Baptist church's members at a tremendous disadvantage. Their friends and neighbors who belong to the PTA or the Boy Scouts or the Humane Society have real authority backing up their group's rules because they know the legal system is open to them. The Baptist church's rules would have little real-world authority because the law would not stand behind those rules. In reality, American law has stood behind the rules agreed to by religious believers unless those rules conflict with important public policies. Courts, for example, are obviously not going to enforce a Mayan rule about child sacrifice. But in the vast majority of cases, courts enforce religious rules. Sometimes this enforcement is through statute. Section 91 of the New York Code lays out the rules for a variety of religious bodies, primarily Christian denominations. The rules are established by the churches, then incorporated into the statute. For example, the provision in the New York Code on Roman Catholic churches identifies who can serve as trustees of the church, the term of office for lay people who serve as trustees, and requires that any act of the trustees be valid only if the bishop or the bishop's designee approves. That's in the New York Code. To take another example, in the wake of the priest sex abuse scandal in the Catholic Church, several dioceses have declared bankruptcy. The courts have wrestled with whether to apply state property law or canon law in deciding the disposition of church property. There are cases on both sides of that question. But it's important to note that the inquiry turns not on the fact that canon law is somehow a foreign law, but simply on whether the source of law would provide the proper balance between First Amendment rights, the church's accountability for its wrongs, and the payment of tort judgments to plaintiffs. In some cases, applying canon law is the most sensible approach, and courts don't hesitate to do just that. Canon law is not a dirty word in the American court system, and Sharia should not be either. Now, a critic might point out that this deferential approach is fine for religious organizations, but in the cases at issue in the Sharia law debate, we're usually talking about claims between individuals who are more vulnerable. Well, 2 points I think bear noting. First, the rules for religious organizations are upheld in court against or in support of claims brought by individuals, such as by an employee who is terminated by the religious organization. And second, courts have also made space consistently for the enforcement of agreements between individuals based on Christian principles. For example, Peacemakers Ministries is a large Christian conciliation ministry. Here's how they describe their conflict resolution work. They call it a commitment to biblical conflict resolution. It says, as people reconciled to God by the death and resurrection of Jesus Christ, we believe that we are called to respond to conflict in a way that is remarkably different from the way the world deals with conflict. We also believe that conflict provides opportunities to glorify God, serve other people, and grow to be like Christ. That's their description. Sounds pretty religious to me. The process can and often does result in arbitration, which means that the parties agree to be bound by the results, and the arbitration ruling is thus enforceable in court. Courts have not blinked an eye about the prospect of enforcing a, quote, biblical conflict resolution. For example, in the case Prescott versus North Lake Christian School, a federal court in Louisiana affirmed an arbitration award that was based on the application of, quote, biblical law and the rules of procedure for Christian conciliation. In another case, Encore Production versus Promise Keepers, the court refused jurisdiction over the case at all because the litigants hadn't gone through the Christian arbitration that they had agreed to in the first place. So the court said, we're not even dealing with this until you've gone through Christian arbitration. A common example of a contract clause that is in these cases is provided by Peacemakers, and the clause reads, the parties to this agreement are Christians and believe that the Bible commands them to make every effort to live at peace and to resolve disputes with each other in private or within the Christian church. Then it cites passages from Matthew and from 1 Corinthians. Therefore, the parties agree that any claim or dispute arising from or related to this agreement shall be settled by biblically based mediation and, if necessary, legally binding arbitration in accordance with the rules of procedure for Christian conciliation. If the parties enter into an agreement like this voluntarily, courts will enforce it. The fact that the agreement subjects parties to a set of binding norms that are separate from American law does not invalidate it. Or even outside the business context, a Christian couple could enter into a prenuptial agreement based on biblical principles. Provided that the agreement was entered into voluntarily, does not disavow child support or purport to settle child custody disputes on some basis other than the children's best interest, or contain some other unconscionable terms, most courts will enforce the agreement as written, just as they would enforce any other prenuptial agreement. The religious basis of the terms does not provide a separate obstacle to the enforcement of the agreement. In fact, several states have gone so far as to incorporate what I see as a form of Christian prenuptial agreement into their marriage laws, permitting couples to opt for a covenant marriage instead of the prevailing no-fault divorce regime. The covenant option is not explicitly Christian in the laws, but it's without question shaped by Christian beliefs and commitments. Let me step back for just a moment and note that our legal system's willingness to accommodate the religious beliefs of the citizens is itself in keeping with the Christian tradition. American law takes the liberty of conscience seriously, not just out of our own individual self-interest, but out of respect for those whose consciences differ from our own. This is a long-standing Christian commitment back to the time of the Apostle Paul, who advised Christians to abide by the dictates of an unbeliever's conscience when dining at the unbeliever's table. This is from 1 Corinthians. He writes, "Whatever is sold in the butcher shop, eat, asking no question for the sake of conscience, for the earth is the Lord's and its fullness. But if one of those who don't believe invites you to a meal and you are inclined to go, eat whatever is set before you, asking no questions for the sake of conscience. If anyone says to you, 'This was offered to idols,' don't eat it, for the sake of the one who told you, and for the sake of conscience. For the earth is the Lord in all its fullness. Conscience, I say, not your own, but the other's conscience." In other words, our attitude toward another's invocation of conscience is determined not by the correctness of the judgment, but by our respect toward the person who invokes it. Now, let me just, as I start to wrap up, I'll admit I have a hard time focusing my arguments precisely on this bill because I have a hard time getting my mind around what this bill is trying to do. By its terms, the proposed bill is limited to, quote, foreign law, which is defined as, quote, any law, legal code, or system of a jurisdiction outside of any state or territory of the United States, including but not limited to international organizations and tribunals, and applied by that jurisdiction's courts, administrative bodies, or other formal or informal tribunals. My concern stems from the fact that Sharia does provide the legal codes of several foreign jurisdictions, but American Muslims may have agreed to follow Sharia not because it's the law of a foreign jurisdiction, but because it's a defining element of their faith tradition. When two Christians enter into a prenuptial agreement that, based on biblical principles, imposes financial penalties on a spouse for adultery or abandonment, and a predominantly Christian country takes the same approach, does the prenuptial agreement amount to foreign law simply because it happens to track a foreign jurisdiction's laws? If that's not what the bill's framers intend by defining foreign law in this way, they need to make that clear. If we're not prepared to call an American Christian's invocation of biblical principles foreign law, then we shouldn't attach that label to an American Muslim's introduction of Sharia. The bill also limits its application to, quote, actual or foreseeable violations of the constitutional rights of a person caused by the application of the foreign law. I don't know what this means precisely. If this means that a court cannot enforce an agreement between the parties in which one of the parties agrees to waive rights guaranteed under the Constitution, then we have a problem, because that rationale would wipe out a lot of what courts do every day. I'm not a criminal law expert, but I think plea bargain agreements are pretty clear waivers of constitutional rights. Now, you can't waive all constitutional rights. No one can sell themselves into slavery, for example, but courts routinely uphold agreements that would be clearly unconstitutional if they were imposed on an individual by the government. Restrictions on employment or speech would be leading examples of this sort of contract. I don't know why a voluntary waiver of a constitutional right should be precluded for religious believers if it's not precluded for non-religious believers. Alternatively, if the violations of constitutional rights language aims to ensure that American courts don't enforce a foreign court's order if the foreign procedures are not fundamentally fair or otherwise violate basic due process, I'm not sure why we need such a provision. American courts are already focused on that. And I'm not sure how or why concerns about Sharia law contribute to our understanding of this issue. If a contract is entered under duress or through coercion, or if a foreign court order is entered without a party having the chance to contest it, our courts won't enforce that contract or order, regardless of the source of the substantive norms embodied in the contract or the order. The unenforceability has nothing to do with Sharia. Sometimes proponents of anti-Sharia legislation insist that these new laws are not in tension with religious liberty. Muslims, the argument goes, can still believe in whatever rules they choose as long as they keep the rules out of our court system. Such responses derive from a superficial conception of religious freedom, or what we often call the liberty of conscience. Suggesting that Muslims or Christians or Jews can honor their consciences by keeping their beliefs out of the legal system ignores the fact that conscience has always been understood as moral belief applied to conduct. Respecting conscience as an internalized set of beliefs does not authentically respect conscience. A system that takes religious liberty seriously has to support the application of belief to conduct, and a key means of support is to give religious believers the same access to courts that non-believers have. permitting religious believers to order their own affairs is in keeping with the deepest commitments and values of our legal system. Anti-Sharia legislation does not defend against theocracy. Such laws call into question our society's fundamental commitments to meaningful religious liberty and meaningful access to the courts. These commitments have been relied on by generations of Protestants, Catholics, Mormons, and Jews, and yes, now by Muslims. As we become more and more religiously diverse, now more than ever is the time to stand by those commitments, not to abandon them. Thank you.